Mr. Lucas, good morning.
Good morning, Your Honor. Let me put on a jacket if you don't mind. I didn't think we'd get called so fast.
What case do you have?
I have actually three matters. I have two at 10 o'clock and one at 11 o'clock.
Okay, what do you have at 10 o'clock?
I have a 10 o'clock pretrial conference, and that is case number 23145835. And that is Oakland Community College versus Destiny Graham Hollings.
Okay.
And that's a pretrial. And then I have a summary disposition hearing, and that is DNF Associates versus Sonia Schuerman.
All right. You ready to go on that?
I'm ready to go on all of it. Yes, sir.
All right, let's get dressed and we'll get started. Get soon in here. Good morning.
Good morning, Judge. Joe Lucas, here on the case of DNF Associates versus Sonia Schuerman.
Your bar number?
P59595.
And what is your name, ma'am?
Sonia Schuerman.
We are on the record calling 22192-518 DNF Associates versus Sonia Schuerman. Date and time by notice dated June 23rd, 2023, for defendant plaintiff's motion for summary disposition. Ms. Schuerman, did you file an answer to the motion for summary disposition?
I did.
When did you do that?
I had it sent to the law office a while ago. I had it notarized and everything.
When was that, ma'am?
Actual dates. Hold on one second. I do have the post office information. One second, please, Gianna. I apologize. I'm going in my email. I apologize, sir. June 20th, sir.
June 20th?
Yes, sir.
Did you serve a copy to the court?
No, sir. No, sir. No, sir. It was sent directly to the law office.
Mr. Lucas?
Your Honor, my records show that we received only responses to discovery requests. We did not receive a response to our motion for summary disposition.
Did you send discovery request or response to a motion for summary disposition? They're two separate things.
Yes, I apologize. I'm glad for the clarity. No, it was the answers.
Okay, so
Yeah.
let me make sure I understand the procedural posture we're in now. We
Okay.
have a motion for summary disposition that has been filed and is on for hearing today, and you did not file an answer to that motion for summary disposition. Is that
No,
correct?
I didn't. That is correct, Your Honor.
Okay, Mr. Lucas, your motion.
Yes, Your Honor. We're here because our contention is there is no genuine issue of material fact. We have filed the complaint. It's been properly served. We have attached a statement of accounts. Ms. Schuerman has merely responded with just general denials. It's not my account. It's not my debt. I don't have anything to do with it. However, Your Honor, the plaintiff in this matter sent billing statements for several months to the address on Peterborough. I don't know how she could not be aware of this indebtedness that was being claimed. It's our position that that she owes the debt, regardless of who used the credit card. And she's responded with no evidence, statements, documents to refute any of the plaintiff's claims. And therefore, I think we're entitled to judgment as a matter of law.
Ms. Schuerman, you did not file an answer to the motion for summary disposition. Is there anything you want to say?
Yes, sir. I did, well, that's just what happens when you don't know, but I apologize for that, to the both of you. Regarding my position here is that in lieu of the case that came at hand, I didn't know about this debt before that. And like I said, I'm not sure about what happened. I do have people that live here. I do not know what's happening. And I have not seen a contract, haven't seen anything. And I don't know, I'm not representing myself well. And I apologize for that. And but all I know is I just, I don't know anything but to fight back.
All right.
That's all I know.
Thank you. The court's prepared to rule in this matter. Plaintiff has filed a motion under MCR 2.116C10, claiming that there's no genuine issue of material fact and that the moving party is therefore entitled to judgment as a matter of law. By way of background, this is a complaint filed by the plaintiff against the defendant alleging money due and owing on a revolving credit line. There are two, I guess, really significant things that are controlling the court's ruling in this matter. First of all, MCR 2.116G4 is quite specific. When a motion under subrule C10 has been filed in the court, by the moving party, the opposing party cannot rely upon their mere pleadings, but must, by affidavit or as otherwise provided in court rule, show that there is a genuine issue of material fact. Otherwise, judgment is to be entered in favor of the moving party. In support of their motion for summary disposition, the plaintiff provided, as part of Exhibit 2, copies of requests for admissions, which were served on the defendant on or about December 12th, 2023. Now, Ms. Schuerman says that she filed on or about June 20th answers to discovery. I'm assuming that would include the request for admissions. That, however, would have been far beyond the 28 days that she's permitted to do so under the court.
Hello,
Hello, what is your name?
Jasmine Howard.
Hold on. You have the wrong name on the screen. Otherwise, I would not have known to call you.
I'm sorry. So I had trouble setting up my Zoom account on my laptop. So I used my son's. I'm sorry.
I'm going to get the other side here. We're going to get started.
Okay.
We are on the record. This is file number 23-149-064. BCG Equities LLC versus Jasmine Howard. Could I have your appearances?
Good morning, Your Honor. Attorney Richard Stuckroth appears for the plaintiff, BCG Equities LLC, P85814.
And tell us your name again, ma'am.
Jasmine Howard. Jasmine Kaylee Marie Howard.
All right, this is our first pretrial in this matter. Counsel, what is your claim about?
This is in regards to a you-own leasing agreement. It appears that there is a piece of furniture purchased. Parties have been in discussion, Your Honor. There is some concern that, number one, this is fraud, as well as some concern that maybe the individual appearing this morning is not the Jasmine Howard in question.
Okay, help me out. I'm not understanding that.
So again, not to put words in anyone's mouth, I'm seeing an affidavit of service that an individual named Jasmine Howard was served at 3990 Berkshire Street in Detroit, Michigan. The Jasmine Howard that appears this morning does not reside at that address and has never resided at that address. Instead, this Jasmine Howard that appears this morning received a notice from an attorney attempting to obtain his services that was mailed to a Litchfield Road address. This Jasmine Howard contacted the court to obtain the filed documents, and that is where we're at now. She believes that this is a case of fraud, but I don't think that this Jasmine Howard is either the correct defendant or there's an issue with the fraud affidavit.
Okay. What's your position here, ma'am?
Just making sure that I'm not held accountable for what the other Jasmine Howard owes.
All right, well, let's do this. What I'm going to do is I'm going to open your written discovery and I'm going to give you a return date. Now, have you sent out your fraud affidavit already, counsel?
Yes, and I've received it back from Ms. Howard, so I'm in the process of reviewing
Process
the
of
documentation.
forwarding it on.
Yeah.
Okay, so
Yeah.
let's kind of just open our written discovery and then you forward on that fraud affidavit and maybe that will get our matter resolved. Okay?
Understood.
I'm going to see you guys next August 17th at 10 o'clock. Does that work for everybody?
Yes.
That work
That
for you?
should
sir?
work for plaintiff.
Okay,
Yes.
August 17th at 10 o'clock. Your written discovery is now open, and I'll note that a fraud affidavit has been submitted. Okay?
Okay.
Thank you, Honor.
All right.
Hello, Judge.
Good morning. I do not have an opponent for you as of yet.
No, and I don't think you will, Judge, because I have in front of me, I have a completely signed conditional dismissal.
Oh.
I see that it's dated the 17th of July, which means I filed it with the clerk's office yesterday on the 18th, and here we are on the 19th. So,
No?
Judge, I mean, we can wait till, 10:30 if you want.
Well, there's no point. If the other side isn't coming, you can go do something useful. Today's the 20th, not the 19th.
Oh, my mistake. I'm time traveling, I guess.
Let's
So-
call the file. Let's get done. We are on the record. This is file 23-145-031 LVNV funding versus Charlotte Puttick Hendrick. This is date and time for our first pretrial. Your appearance.
Judge, may it please the court, I am Attorney Richard Rusin. I'm the attorney of record for the plaintiff. I have a bar number of 35222, and I appear today on behalf of the plaintiff.
Mr. Rusin, you were telling me good news. The case was done.
Well, I live to serve. But anyways, basically, I have in my hands, Judge, a fully signed and executed conditional dismissal. And I see that it is dated by both me and opposing counsel July 17th, which means that I filed it myself with the clerk's office on July the 18th. Here we are today on the record of July 20th. I rather suspect that since I filed this conditional dismissal on the second floor clerk's office, that it will be promptly, although not at the moment, coming to your chambers for entry. Therefore, Judge, I asked for a short 30-day adjournment for control purposes so that the conditional dismissal may be entered and the case closed.
There's no reason to have a control date on this matter. I accept your representation as an officer of the court that you filed with the court a couple of days ago, a signed and executed conditional dismissal. We are on the record calling file number 23145-835, Oakland Community College versus Destiny Graham Hollings, by notice dated June 21st, 2023, and sent to the parties on that date. This matter is scheduled for pretrial today, July 20 at 10 o'clock. It's now after 10:30. Could I have your appearance?
Joseph A. Lucas, P 59595 for the plaintiff.
Mr. Lucas, the defendant has failed to appear. No good cause for that failure having been shown. The fault of the defendant is hereby entered. So we'll send that on out to you today. And you have, you told me at 11 o'clock with me.
Yes, Your Honor.
You want me to release you, or you want to stay in the waiting room, or you want to Go and come back. It's up to you.
I'll go and come back.
Okay, then I'll remove you now to CA 11. Thank you for coming.
And your honor, sorry about that. I just wanted to clarify something. The default is under, will there be a default judgment as well, or do I apply for that after the default is entered?
You have to serve the default on the other side, provide the SCRA status report and your proposed default judgment.
Gotcha. Thank you, sir. I appreciate it.
Maxine Easley Miller.
You have a case with Southfield Neurological.
Yes.
All right, let's get started. All right, we are on the record calling file
Okay.
number 23150-762, Southfield Neurological versus Maxine Easley. Your appearances.
Yes.
Tell me your name, ma'am.
My name is Maxine Easley Miller.
Counsel, your appearance.
Joseph A. Lucas, P 59595, appearing on behalf of the plaintiff.
All right, this is our first pretrial in this matter. Ma'am, is it your intention to represent yourself in this matter, or are you going to hire a lawyer?
No, I can't afford a lawyer. I have to
Okay,
represent myself.
you have an absolute constitutional right to represent yourself. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the very same rules that bind that lawyer are binding on you. Do you understand that?
Yes.
Okay. The counsel, what's your claim about here?
Your honor, it's just for some costs for medical services that were rendered, seeking damages of $877.95 plus allowable costs.
What's your position here, ma'am?
I do owe them. It wasn't that I wasn't trying to pay. The fact of the matter is that a lot of traumatic events occurred during the time of process. I'm sure they mailed the bill out. However, due to the fact that my daughter had COVID, her lungs collapsed, and my mother passed, and my son was shot while someone was attempting to rob him. So it just, everything was just building up. And I'm sure, like I said, I'm sure they sent a bill. However, I don't remember seeing it, unfortunately,
Okay.
due to my circumstances.
Then this is what I'm going to do. I'm going to open your written discovery. I'll give you a return date. Your return date with me will be August 17th at 11 o'clock. Is there anything else
Okay.
accomplished today?
Yes, what I wanted to do is, my kids have put together a small payment of $650 to pay the neurologist, and I would make some arrangements. However, the paperwork that was sent out by the law firm, it was kind of confusing, and there were so many things I needed to put in as bill collectors and debtors. So it just.
Okay, well, here's what I'm going to do. I'm going to put you guys into a chat room and you can have your conversation. And if you get the case settled, then fine. If not, I'll see you again August 17th at 11 o'clock. So let me get you in the chat room so you can have your conversation. Your written discovery is now open.
60 days for that, your honor, for written discovery.
Our counsel, I let it go as long as parties are doing something.
Oh, all right.
You know, but when I come back and I ask, what have you done? We are on the record calling file 23149-465, Garden Fresh Marketplace Incorporated versus Ali Abdul Muhammad Masela. We were last together on this file on June 22nd, 2023, at which time the parties and, the court and counsel for both sides agreed to today's date, July 20th, 11 o'clock for our next pretrial. It's now after 11:30. Could I have your appearance?
Alan Soroki, P37441, appearing on behalf of the plaintiff, Your Honor.
Mr. Soroki, the defendant has failed to appear. No good cause of that failure having been shown. The default, the defendant is hereby entered. We'll send that on out to you today, sir. Thank you for coming in.
Your Honor, am I able to enter an order with the court by email?
The
I
court,
don't know if you.
you'll have to serve the other side with a copy of the default. and you have to provide your SCRA status report and your proposed default judgment. If you want to do that by email, you can. The court has a portal. You just go on the court's website.
Okay, thank you very much.
23149-184 Midland Credit Management versus Fuentes Jeremy Johnson by a notice dated June 23rd, 2023, and sent to the parties on that date. This matter is set for pretrial today, July 20th at 11 o'clock. It's now after 11.